Ma'am, put the phone down. Put it down right now.
My name is Deja Williams. I'm standing on my own front porch on my own property filming a public street.
I'm giving you a lawful order. Put the phone down.
But what happened next?
I have a constitutional right to record police activity in a public space. I am not interfering with anything. I am not touching anyone. I am not within 10 feet of your officers. I am on my porch. Put the phone down or you will be placed under arrest. For what? For recording on my own porch. Ma'am, this is your last warning. Then I want you to know that this phone has been uploading since the moment I pressed record. Whatever you do next is already in the cloud. Now tell me what law I am breaking by standing on my own porch with my phone. Deja Williams was 29 years old. She was a licensed practical nurse. She had lived in the same house on Caldwell Street in Memphis, Tennessee for 3 years, a house she rented, a street she knew. A neighborhood where she had grown up 6 blocks away, and where her mother still lived, and where she knew, by name, most of the people who lived within 4 houses in either direction. She had no criminal record. She had never been arrested. She had never, in 29 years, had a significant interaction with law enforcement of any kind. She had been sitting on her front porch at 8:47 p.m. on a Tuesday in August when 3 Memphis Police Department patrol cars pulled onto Caldwell Street and stopped in front of the house 2 doors down, the house where a man named Curtis Pratt lived, a man Deja had known since childhood, a man who was, at the moment the patrol cars arrived, sitting on his own front steps eating a sandwich and talking on his phone. She watched 4 officers approach Curtis Pratt. She watched the interaction escalate in under 90 seconds. The commands, the resistance that was not resistance but confusion. The hands that went up and then were grabbed before they were fully up, the sandwich that fell onto the steps. She watched Curtis Pratt go face down on the sidewalk with 2 officers on top of him while he was saying, clearly enough that she could hear it from 2 houses away, that he did not understand what was happening and that he had not done anything. She picked up her phone and pressed record at 8:49 p.m. She was on her own porch. She was 11 feet from the edge of her property. She was 37 feet from the nearest officer. She did not speak. She did not move toward the officers. She did not interfere with the arrest in any way that any definition of interference, legal or otherwise, has ever encompassed. She pressed record, she held the phone steady, and she made sure in the first 15 seconds that the footage clearly showed the street sign, the house numbers, the officers' badge numbers, and Curtis Pratt's face, because she had learned, from 29 years of living in this neighborhood and watching things happen on these streets, that the details that matter most are the ones that disappear fastest if you do not document them. What happened in the next 41 minutes was captured on Deja's phone, on the body cameras of 4 Memphis Police Department officers, on a neighbor's porch camera across the street belonging to a retired teacher named Ms. Gloria Hutchins, who had activated it remotely from inside her house when she heard the patrol cars, and on Deja's phone's automatic cloud backup, which had begun uploading her footage to her cloud storage account at 8:49 p.m. The moment she pressed record, and which completed the full upload at 9:03 p.m., 11 minutes before Officer Dennis Air LPH Caulfield walked onto her porch and took the phone out of her hand. That upload was the fact that everything else in this story turned on. Those recordings would be reviewed by the Shelby County District Attorney's Office, entered into evidence in 2 separate criminal proceedings that were both dismissed, presented to the Memphis City Council's Public Safety Committee, cited in a civil rights lawsuit filed in the United States District Court for the Western District of Tennessee, and result in a $7.1 million verdict that restructured the Memphis Police Department's recording interference policy and generated a Department of Justice guidance document on citizen recording rights that was distributed to law enforcement agencies in all 50 states. Before we go any further, where are you watching from tonight? Hit that subscribe button if you're new here. Stories like this one are exactly why this channel exists. And your support is what makes it possible to keep telling them. Officer Dennis Ralph Caulfield had been a Memphis Police Department patrol officer for 8 years. He had standard use of force certification, standard de-escalation training, and what his performance file described as strong situational awareness in high-tension community interactions. He had received, as all Memphis PD officers had received following a 2019 department policy update, explicit training on the constitutional right of civilians to record police activity in public spaces, training that specified, in language that left no ambiguity, that officers could not lawfully order a civilian to stop recording, could not confiscate a recording device without a warrant, and could not use obstruction charges as a mechanism for suppressing documentation of police activity. He had received that training. He had signed the acknowledgement form. His signature was in his personnel file and would be entered into evidence 14 months later. He was the officer who walked onto Deja Williams's porch. The sequence that preceded his arrival on her porch began at 8:51 p.m., 2 minutes after she started recording. His body camera recorded him noticing her from the street. It recorded him watching her for 40 seconds, a woman on her porch, phone extended, recording the arrest in progress, and it recorded the specific quality of attention he gave her that was different from the attention you give a bystander, and more like the attention you give a problem you have not yet decided how to solve. He said something to the officer beside him. The body camera's directional audio did not capture it clearly. What it captured clearly was what happened next. He broke away from the arrest scene and walked toward Deja's porch. "Ma'am, I need you to put the phone down." Deja's phone recording captured her response, not panic, not aggression. The specific clarity of a person who knows exactly what she is doing and exactly what right she has to do it. "I'm on my porch recording a public street. That's a constitutional right. I'm not interfering with anything. You're interfering with a police operation. I'm standing on my porch 11 feet from the edge of my property." "How is that interfering?" He told her again to put the phone down. She told him again that she would not. Her phone's recording captured her hands, steady, the phone level, the frame clear. Her face visible in the front camera reflection as a person who is frightened and is not letting the fear move her hands. He called a second officer over. The second officer's body camera activated as he approached the porch steps. It recorded Deja Williams on her own porch. Phone extended, recording, not moving toward anyone, not speaking loudly, not threatening anyone. Doing nothing except documenting what was happening on a public street from her own private property. "Ma'am," the second officer said, "if you don't put that phone down, you're going to be placed under arrest for obstruction." "Obstruction of what?" she said. "I'm on my porch. Curtis Pratt is 37 feet away. I haven't said a word to your officers. I haven't moved. I haven't touched anyone. Obstruction requires interference with a lawful police action. I am not interfering. I am recording. Those are not the same thing. Last warning." She looked at both officers. Her phone's front camera captured her face in that moment. The expression of a person who has just completed a specific internal calculation and arrived at a specific conclusion and is about to speak. From that conclusion, rather than from the fear that is also present and visible and real. "This footage has been uploading since I pressed record," she said. "It uploaded 11 minutes ago. You can take this phone. You cannot take what's already in the cloud. Whatever happens next is already saved. So I want you to think carefully about what you do next, because the record already exists and it is not going anywhere." Caulfield stepped onto her porch at 9:14 p.m. He placed her under arrest for obstruction of a governmental operation under Tennessee Code Annotated Section 3916-6-2. He took the phone from her hand. He walked her down her porch steps in handcuffs, past Ms. Gloria Hutchins's porch camera across the street, which recorded everything with the fixed and patient eye of a device that has no stake in the outcome and simply captures what is in front of it. Deja Williams was processed at the Shelby County Criminal Justice Center. She was held for 4 hours. She was released at 1:22 a.m. She walked out of the Justice Center and called her mother from a borrowed phone because hers had been seized as evidence, and she stood on the sidewalk outside the Justice Center in the August heat and told her mother what had happened, and then she stood there for another few minutes after the call ended, doing the specific arithmetic of what the night had cost and what it was going to cost and what she was going to do about it. She had already decided before she went inside to make the call. Curtis Pratt had been charged with resisting arrest and assault of an officer. The assault charge was based on a single officer's statement that Pratt had struck him during the takedown. None of the 4 body cameras captured the alleged strike. Deja's footage, shot from 37 feet away, showed the sequence in sufficient detail to raise significant questions about the officer's statement. The cloud upload, completed at 9:03 p.m., 11 minutes before the phone was seized, meant that the footage existed independently of the confiscated device. In an account that the Memphis Police Department had no warrant, no authority, and no mechanism to access. The Shelby County District Attorney's Office received both case files within 72 hours. A prosecutor named Assistant District Attorney Renata Booker reviewed them. She watched the body camera footage. She reviewed Deja's cloud footage, which Deja's attorney had provided directly. She read the obstruction statute. She read the 2019 Memphis PD policy on civilian recording rights. She read Caulfield's signed acknowledgement form. She dismissed both cases, Curtis Pratt's resisting and assault charges, and Deja Williams's obstruction charge, within 10 days of receiving the files. Her dismissal memo, entered into the public record, was 4 pages long. Its conclusion was one sentence: "The evidence does not support the charges as filed," and the circumstances of both arrests raise serious concerns about the appropriate use of police authority that warrant independent review. That sentence was the beginning of everything that followed. Deja retained an attorney named Marcus Thregel, 33 years of civil rights and police misconduct litigation in Tennessee and the Sixth Circuit. Former counsel to the ACLU of Tennessee's Police Accountability Project. A man who had argued recording rights cases before federal courts, and whose filing history included the precedent-setting Sixth Circuit decision that established the clearest articulation of the right to record police in Tennessee's federal jurisdiction. Thregel watched all the recordings in sequence. He watched them twice. He read the 2019 policy acknowledgement. He read the dismissal memo. He reviewed Caulfield's body camera footage of the 40 seconds he spent watching Deja before he walked toward her porch, the specific quality of attention. The conversation with the officer beside him, whose audio the camera had not captured clearly, the decision to break away from the arrest scene. He read the obstruction statute. He read the case law. He sat quietly for a moment. "There are 4 things this case is about," he told Deja. "There is an officer who received explicit training on your right to record, signed a form acknowledging that training, and arrested you anyway. There is a department whose own policy prohibited what that officer did, and whose training failed to prevent it. There is a charge, obstruction, that has been used in this city and in cities across this country as a tool for suppressing documentation of police activity, and whose application here was so far outside its statutory definition that a prosecutor dismissed it in 10 days without a hearing." He paused. "And there is a phone, and a cloud backup that completed 11 minutes before they took the phone. And that detail, that 11-minute window, is the detail that is going to make this case different from every other recording rights case that has come before it. Because it is not just a case about the right to record. It is a case about what happens when they cannot take the record away." The federal lawsuit was filed in the United States District Court for the Western District of Tennessee. Deja Monique Williams and Curtis Dewing Pratt versus the City of Memphis, Officer Dennis Ralph Caulfield individually, and 3 additional officers individually. The complaint alleged violation of the First Amendment right to record police activity, violation of the Fourth Amendment right against unreasonable seizure of a recording device without warrant, violation of the 14th Amendment Equal Protection Clause, 42 U.S.C. Section 1983, Civil Rights Violations, malicious prosecution, intentional infliction of emotional distress. An account specific to the recording context, retaliatory arrest, that cited the Supreme Court's 2019 decision in Neves v. Bartlett and argued that the absence of probable cause for the obstruction charge, combined with the timing and circumstances of the arrest, established retaliation for protected First Amendment activity as the operative cause. That final count was the one that made police accountability scholars across the country take notice. It was the one that transformed a local police misconduct case into a national precedent on the intersection of recording rights, retaliatory arrest doctrine, and the specific legal implications of cloud storage technology for evidence preservation in police encounters. The city's initial offer was $85,000. Thregel sent back 3 words, "See you there." The trial began 16 months later. The courtroom held every day an attendance that told its own story: journalists and civil liberties advocates, members of Memphis's black professional and community organizing networks, law students from the University of Memphis and Vanderbilt who had followed every filing, representatives from the Reporters Committee for Freedom of the Press and the Electronic Frontier Foundation who had filed amicus briefs on the recording rights and cloud storage questions. National media that had covered the case since the cloud backup detail first appeared in a legal filing and generated the specific kind of viral attention that attaches to a fact that everyone immediately understands. Ms. Gloria Hutchins sat in the gallery every day. She wore the same cardigan she had been wearing the night she activated her porch camera from inside her house. She told an interviewer before the trial that she had activated it because she heard the patrol cars and thought, "Someone needs to be watching this." She had been right. Curtis Pratt sat in the gallery every day in the same clothes he had been wearing on the night of his arrest. The clothes he had put on that morning to sit on his own front steps and eat a sandwich. He had suggested it to Thregel. Thregel had told him it was the right instinct. Deja Williams sat at the plaintiff's table. Her phone, returned after the criminal case was dismissed, the footage still intact on the device, was on the table in front of her. Her cloud storage account was open on a tablet beside it, the upload timestamp visible. 9:03 p.m. 11 minutes before they took the phone. The footage was played on the first morning. All 5 recordings simultaneously. Deja's phone, 4 body cameras, Ms. Hutchins's porch camera, on a display that allowed the jury to watch the same 41 minutes from 6 different angles at the same time. The jury watched a woman on her own porch, 11 feet from the edge of her property, 37 feet from the nearest officer, holding a phone steady with both hands. They watched an officer spend 40 seconds watching her before he walked toward the porch. They watched the conversation, her citation of her rights, her knowledge of the statute, her statement about the cloud upload. The specific and extraordinary composure of a person who is frightened and is not letting the fear move her hands. They watched her be handcuffed on her own porch and walk down her own steps in front of her neighbor's camera. They watched the timestamp on the cloud upload, 9:03 p.m. They watched the timestamp on Caulfield's body camera as he stepped onto her porch, 9:14 p.m. 11 minutes. The record was already saved before he got there. 6 jurors were visibly emotional when the footage ended. The others wore the expression of people who have just had something explained to them that they already understood, but had never seen documented this clearly: the specific transaction of a person exercising a right, an officer deciding that right was a problem, and an arrest that had no purpose except to make the documentation stop. Except it hadn't stopped, it was already in the cloud. Deja testified for 7 hours over 2 days. She described the neighborhood, Caldwell Street, the houses she knew, the people she had grown up with, Curtis Pratt on his front steps eating a sandwich. She described pressing record. She described the feeling of holding the phone steady while the fear moved through her, and she did not let it reach her hands. She described Caulfield walking toward her porch and the decision she made in the seconds before he arrived. Not a decision to resist, not a decision to escalate. The decision to say one true thing clearly, and on the record before whatever happened next happened. "I told him the footage was already in the cloud," she said, her voice carrying the flat precision of a person who has had 16 months to understand what she is saying and has chosen every word accordingly. Not to threaten him, not to be clever, because it was true and I needed him to know it was true before he made a decision he could not take back. I needed the record to show that I told him. She paused. He made the decision anyway, and I have spent 16 months thinking about what that means, not what it means legally, Mr. Thregel handles that, what it means about what I was to that officer in that moment, what category I fit into. What the phone in my hand looked like to him versus what it actually was. Another pause longer. It was evidence. That is what it was. I was making evidence. And the arrest was about stopping the evidence from existing, except it already existed. It had been in the cloud for 11 minutes. The evidence he was trying to stop had already outlived the moment he was trying to prevent it from capturing. She described the processing, the 4 hours, the borrowed phone. The call to her mother. The sidewalk outside the Justice Center at 1:22 a.m. I stood there for a few minutes after I hung up, she said. And I thought about the upload. I thought about the fact that the footage was sitting in a server somewhere that they could not touch, that no warrant they filed would reach. That existed completely independently of anything they had done or could do. And I thought the record survived. Whatever else happened tonight, the record survived. She paused. And then I went home because I had a nursing shift at 6 a.m. And people who needed care and a job I was not going to let that night take from me too. She had gone to work. She had worked her full shift. She had come home and called Thregel. The expert witnesses covered every dimension of the case with the thoroughness of a legal team that understood it was building a precedent, not just winning a verdict. A First Amendment scholar from Vanderbilt Law testified that the right to record police in public spaces was among the most clearly established rights in current constitutional jurisprudence, and that Caulfield's conduct fell outside every legal boundary governing that right, with a clarity that his signed policy acknowledgement made essentially indefensible. A digital forensics expert testified about cloud auto-upload technology, how it works, what it preserves, why the 11-minute window between the upload completion and the phone seizure meant that the evidence existed in a legally distinct form that no subsequent police action could touch. A police practices expert testified that retaliatory arrest for recording had been documented in police misconduct cases in 31 states, and that the pattern officer notices recording. Officer approaches. Officer arrests on obstruction matched a documented template of recording suppression that was sufficiently consistent across jurisdictions to constitute evidence of a widespread practice rather than isolated misconduct. A mental health expert documented the specific trauma of being arrested on your own porch, in your own neighborhood, in front of people you have known your entire life, for doing something you had a constitutional right to do. The defense argued that Caulfield had made a good-faith judgment call in a high-tension situation, that the obstruction statute gave officers discretion in assessing interference, and that the arrest had been made in the moment without full consideration of the recording rights policy. Thregel addressed each argument in his closing with 33 years of precision. Officer Caulfield made a good-faith judgment call, he told the jury. He made it after receiving explicit training on exactly this situation. He made it after signing a form acknowledging that he understood that training. He made it after 40 seconds of watching a woman on her porch from a distance of 37 feet and deciding that she was a problem. That is not a good-faith judgment call in a high-tension situation. That is a decision made in full possession of the information that made it wrong. He paused. The obstruction statute gives officers discretion. It does not give them unlimited discretion. It gives them discretion within a statutory definition that requires actual interference with a lawful police action. A woman on her own porch 37 feet from the nearest officer is not within that definition. She is not within a reasonable interpretation of that definition. She is not within a generous interpretation of that definition. Officer Caulfield's signed acknowledgement form proves he knew that. Another pause longer. And the arrest was made in the moment without full consideration. The moment lasted 40 seconds. He spent 40 seconds watching her before he made his decision. In those 40 seconds, he had everything he needed to make the right decision. He had his training. He had his policy. He had his signed form. He had 37 feet of open space between her porch and his officers. What he did not have, what he could not get past, was whatever he decided she was in those 40 seconds. And I am asking this jury to look at the footage of those 40 seconds and tell me what you see. Because what I see is a woman holding a phone. And what Officer Caulfield saw was something that needed to be stopped. The jury deliberated for 7 days. When they returned, Caldwell Street knew before the courthouse did. Word moved through the neighborhood, the way word moves through places where people have been paying attention for a long time, and know what a verdict means for more than the people whose names are on. The filing. Ms. Hutchins was in the courtroom. Curtis Pratt was in the courtroom in his arrest night clothes. Deja's mother was in the gallery and had been every day of the trial and had never once been late. Liable on all counts, every count, against the city of Memphis, against Caulfield individually, against the 3 additional officers individually. The sound in the courtroom was the sound of Caldwell Street, the specific acoustic texture of a neighborhood that has watched things happen on its streets for a long time and has not always seen the record survive and is now sitting in a federal courtroom watching it survive in the clearest possible way. Deja Williams sat at the plaintiff's table with her phone in front of her, and the cloud upload timestamp visible on the tablet, 9:03 p.m. And she looked at it for a moment before she looked at Thregel and then at her mother in the gallery. Her mother was already standing. She was the first person in the courtroom on her feet. She was standing before the last count was read, and she stayed standing through all of them. Deja nodded once. Then she picked up her phone, the same phone, the one they had taken from her hand on her own porch, and she held it the same way she had held it at 8:49 p.m. on a Tuesday in August. Level, steady. Both hands, the way you hold something when you know what it is for. The damages phase lasted 6 days. $2.8 million in compensatory damages. For the wrongful arrest, the malicious prosecution, the reputational harm, the emotional distress, and the specific calculable cost of a licensed practical nurse's professional standing and peace of mind in the community where she had lived her entire life. $4.3 million in punitive damages against the city of Memphis for systemic failure to enforce its own recording rights policy and for the documented pattern of retaliatory obstruction arrests. Total $7.1 million. Caulfield was suspended without pay pending a department review. The review resulted in termination. He appealed through his union. The appeal was pending as of the date of this story's production. The 3 additional officers received formal reprimands and mandatory retraining. The Memphis Police Department, under a memorandum of agreement with the Department of Justice that cited the case as its primary catalyst, implemented a comprehensive revision of its recording rights enforcement policy, mandatory quarterly training on civilian recording rights for all sworn officers, an independent audit of all obstruction arrests in the preceding 3 years cross-referenced against body camera footage showing civilian recording activity, a prohibition on phone seizure without a warrant signed by a judge, and a civilian recording rights liaison position within the department's Community Affairs Office. The DOJ guidance document that followed, distributed to law enforcement agencies in all 50 states, cited the case as the definitive contemporary illustration of retaliatory arrest for recording, and included a specific section on cloud storage technology and its implications for evidence preservation in police encounters. The section was titled, in the document's internal reference system, the Williams Protocol. The Electronic Frontier Foundation cited the case in its annual Digital Rights report as the most significant legal development of the year, in the intersection of recording rights and cloud technology. The Reporters Committee for Freedom of the Press added it to its core legal resources for journalists covering police activity. Law school constitutional law courses from Maine to California added the case to their recording rights units within 1 academic year of the verdict. Deja Williams still lives on Caldwell Street. She still works as a licensed practical nurse. She still sits on her front porch in the evening sometimes, in the same chair, facing the same street, looking at the house 2 doors down where Curtis Pratt still lives and where he still sometimes sits on his own front steps. Her phone has auto-upload turned on. It has always had auto-upload turned on. She told an interviewer once that she had not changed a single setting on that phone since the night of the arrest. Not the upload settings, not the storage settings, not anything. That the phone was doing exactly what it had always done, and that the only thing that had changed was that a federal court had now explained, in a $7.1 million verdict, why that mattered. Curtis Pratt still lives on Caldwell Street. He got a settlement from the separate civil action filed on his behalf, the wrongful arrest, the false charges, the takedown that the body cameras had not supported, and that Deja's footage had placed in sufficient doubt to collapse the prosecution in 10 days. He told an interviewer that the thing he thought about most was the sandwich that fell on the steps when his hands went up. The specific ordinariness of the moment before the patrol cars arrived, sitting on his own steps, eating, talking on his phone. A Tuesday evening in August on a street where he had lived for 11 years. "I wasn't doing anything," he said. "I was just there and then I wasn't." He paused. "Deja was watching. I didn't know she was recording. I didn't know about the cloud. I didn't know any of it." Another pause. "But she knew. She knew what she was doing and she did it, and they took her phone and it didn't matter because she had already done it." The record was already there. He looked at the interviewer. "That's the thing about a neighbor who pays attention. You don't always know they're watching, but they are. And sometimes that's the whole difference." Ms. Gloria Hutchins still lives across the street. Her porch camera is still active. She told the same interviewer that she turns it on every time she hears something on the street that sounds like it needs watching, and that she has turned it on 11 times since the night of August, and that nothing requiring documentation has happened on those 11 nights, but that the camera was ready, and that ready was the point. "The record doesn't make itself," she said. "Somebody has to decide to keep it. Deja decided, I decided, that's all it was." Two women on their porches deciding that what was happening on their street was real, and that real things deserve a witness. She paused. 94 million people saw what we recorded. I think Caldwell Street showed up. The recordings, all 5, synchronized and time-stamped, with the cloud upload timestamp displayed as a 6th data point, became required training material at police academies, civil rights law programs, journalism schools, and digital rights organizations across the country. A 41-minute case study in what the right to record means when the record survives the attempt to suppress it, when the phone goes into evidence, and the footage is already in the cloud, and the arrest that was supposed to end the documentation becomes, instead, part of the documentation, permanent and retrievable, and entered into a federal court record that no subsequent action can touch. In Memphis and far beyond, Deja Williams's case became a landmark, proof that the right to record is only as powerful as the technology that preserves the record. That a cloud upload timestamp can be the most important piece of evidence in a federal lawsuit. That standing on your own porch and holding your phone steady when you are frightened is an act of civic courage that the Constitution protects, and that a jury can value at $7.1 million. And that the record, once made, once saved, once uploaded to a server that no warrant can reach, does not disappear just because someone takes the phone. The record was always watching. The record always wins. If you believe that every person has the right to record what happens on their street, that a cloud backup can be the difference between justice and erasure, and that 2 women on their porches on a Tuesday night in August changed the law for every person in this country who has ever held up a phone and wondered whether it was safe to press record hit, that subscribe button and turn on notifications. Because tomorrow we have another story where the camera told the truth and the truth changed the outcome. The record is always watching, and the record always wins.